ensures that TRIPS requirements are that measures and procedures to enforce intellectual property rights do not themselves become barriers to legitimate trade. So patents in many cases have become barriers to legitimate trade. This is the Doha Declaration I told you. So now I'm going to take you, this is all a little bit of facts and theory. Some recent patent cases. Roche's patent on Pegasus was revoked or now, but Pegasus is pegylated interferon. Interferon, interferon is very important one. And a certain type of pegylation means adding certain glycol molecule to it. I've given this definition of pegylation. Polyethylene glycol, you add it to the thing, it becomes more effective, etc. And it costed over 3 lakhs for a 6-month course. So, on the basis of cost and the basis of the invention was not obvious. Pegylation is a well-known process. Any chemist, any biochemist would tell you pegylation. So, as I said, it should not be obvious to people skilled in the art. So, if it's obvious to chemists, it is not a new invention, new step. So, they said it's not obvious. Invention is held to be obvious. Pegylation is a known process, and therefore we are revoking the patent. Government we had given the patent, then somebody objected, an NGO had objected, Sankalp they have an interest. So this patent was revoked. So which means now a lot of generic manufacturers can come and make. Instead of 3 lakhs, maybe you will see 30,000 as the cost, 20,000 as the cost. So this is the importance of, which is still high, but still it's much better than 3 lakhs. Second was Januvia. This is, gliptins are a class of anti-diabetic drugs. Now this is Merck Sharp and Dohme versus Glenmark. Glenmark is an Indian company. And Glenmark started making generic versions of sitagliptin, Januvia. And Merck said that no, we can't make it, we have got patent on this and so on. So it went to the court and Delhi High Court refused to give injunction on this. We cannot stop its generic production, let them make, because they are making it much cheaper. And one of the things which Merck argued was no drug which is under patent should be given drug approval, which the court refused to agree. Because patents are given by it's a different ministry, different arm of the government. Drug approval is given by the Ministry of Health. Patents is Ministry of Commerce under patents law. Drug approval is given under the Drugs and Cosmetics Act. So the court said we don't care. What is the patent status? These two acts cannot be linked. Drugs and Cosmetics Act operates on its own wisdom. Patents Act operates on its own wisdom. You cannot join these two. So this is called patent linkage. So Merck wanted patent linkage. What they said is, if a drug is under patent, the Drug Control of India should not give it any license for manufacture to anybody else. They think we are not bothered, and drug control should not be bothered. So that is important. So this is important from the point of view of patent linkage is not a concern of the government of India. And this is the famous compulsory license, first compulsory license, sorafenib, Nexavar. And again, it was sold at, is again an anti-cancer drug, it was sold at very, very high price. See the last line, you can see, Bayer's price was 2.8 lakhs. Natco is an Indian company, it was making it 8,000 rupees for a month's whereas 2.58 lakhs and 8,000. So generic version is 8,000 and Bayer's price is 2.8 lakhs. So again it went through various steps, it's all, and this, it was, the court said, we are, in fact, intellectual property, in fact, it was patents controller which gave the compulsory license on these 3 conditions. They will not work sufficiently. There were 1 lakh patients, they were making only for 10,000 people. And it was priced at 2.8 lakhs, it was unaffordable. Many Indian companies were trying to make it 3,000. And then it said, it was not, so see, this point, 1, 2, 3, 4, 5th point. The reasonable requirements of the public with respect to the patented invention have not been satisfied. The patented invention is not available to the public at a reasonably affordable price. And the patented invention is not worked. Again, this is the term. Work means manufactured in India or made available in India or imported by the company. It is not. It is not any of these things. On these 3 criteria, it was said, you are not really obeying the conditions of the patent. Therefore, we are revoking the patent. So revoking the patent means now a lot of generic producers in India can make this one. And now prices really come down. This is the latest, July 19, 2013. This is again used in breast cancer. And again, this was lost practically by Roche because it didn't follow some procedural regularities. They have all kinds of high-flying lawyers who should have studied this Patents Act left and right. But it has things like after 2 years your patent is awarded, you have to pay every year some fees to renew the patent. They haven't paid it. On that alone, the patent was revoked. And then they filed something called additional applications. And they didn't meet the requirements. So it was the divisional application was rejected. And the patent was rejected on this obvious thing. It should have been obvious to any lawyer, any of this. They have a big legal departments. But they didn't pay attention to this. That every year it has to be renewed. They hadn't renewed it. Patent is gone. Of course, there is a procedure for getting back the patent, but it's very complicated. Now Roche is saying that we are not going to pursue the patent in India, which is a big relief because now a lot of generic manufacturers will come and make this. It costs about 900,000 for a minimum course of 12 injections, which is out of the reach of majority of Indian women. So we hope now a lot of generic manufacturers will come and reduce the price. Same thing with Tycab is ophthalmic for eye problems, and this again the government, the patents controller revoked the patent on a particular aspect of the principal drug, but not the salt of the drug. This is another thing. So what are our current concerns? Today in India, when we are trying to fight against the lobbies, free trade agreement lobbies, which want us to extend the patent term beyond 20 years, which is not required by TRIPS, but the free trade agreement, they want to say new use patent, etc. They want us to place limitations in parallel imports of patented drugs. We cannot, if something is available cheaper, we can't import from there. They are saying that. Generic competition को बंद करो. Data exclusivity, patent linkage, which is telling you these two acts were linked, they should not be linked. But they are saying it should be linked. The lobbies are saying it should be linked. So, and then there are trade agreements like ACTA. ACTA is an anti-counterfeit trade agreement. And it is done by some of the G12 countries. Basically, they want to stop transport of generics from India to Brazil or Africa, etc. They all have to go through Amsterdam. And they are saying that once you park it in Amsterdam port, and if you are violating our patents law, we'll seize the whole ship. That's what they did. They seized the whole ship. And it's nowhere in the international law because in every port there is a certain thing called which is about a certain area which is not subject to your law. It's an international area. So the ship is parked in the international area also. They have been seizing the thing. And they are saying they have got a right to seize, and they will also seize even on the mere suspicion something is being violated, and we have no recourse. Whatever the judge says, I can't argue about it. Whatever the judge says, their judge, I have to accept it. And then I have to pay the big fines, etc. So this is the spirit behind ACTA. It has been, even though the European Parliament rejected this, European Commission has gone ahead with this. The European Commission is the government, like imagine the Parliament of India rejects something and the government of India approves. It's something as paradoxical as that, but they have gone ahead. But this is basically directed against countries like India because they are supplying a lot of medicines to Africa. They all have to go through Amsterdam. We'll seize it, we do this thing, we do that. So this is a kind of trade barrier. This is not free trade. And there's a lot of this thing like you open up the Indian market for takeover. So a lot of companies have been, Western companies have been trying to take over successful Indian pharma companies. Already 3-4 companies have been taken over, but now we are trying to say that this should not happen because then we will lose whatever independence we have for making medicines. So this is a campaign that is going on, takeover of companies. And we are saying there should be no dilution of Indian Patents Act 2005 and TRIPS plus measures through FTAs. FTAs means free trade agreement. So, concludingly, this is a kind of war. I mean, this is a war. I mean, war is not only missiles and bombs. This is a war, economic war by other means. And the whole war, as I said, was started in 1984 to see that developing countries do not go ahead with their industries, and the hegemony of the Western farmer, Western industries is still maintained. I mean, putting it a little too crudely, but this is what it is. So I think we need to use as many acts and laws we have effectively to prevent this takeover, because it's in the interest of the people. And once these companies, Western companies take over Indian companies, all prices will go up. Thank you.